All right, this is Rudy Davis. It's June the 24th, Saturday, the year 2017. I've got a document here for Charles Dyer titled 140404-Operation Floodlight, final version. I have no idea who wrote it. I'll try to find out. But I'm going to read it into YouTube, and it may take me several parts, and I'll have to put all these audios together. And I don't know what we're fisting to read. I don't know, just Operation Floodlight. Sounds like somebody put together a lot of facts about the Charles Dyer case. Court transcript and evidence summary. There are several hearings and trials that involve this case. They are referenced as follows: preliminary hearing, PH, Daubert hearing, DH, first trial, T1, second trial, T2, third trial, T3. Post-conviction relief brief. Only a brief summary of the transcripts and evidence is provided, as well as the trial and page numbers in which the summarized information can be found. Copies of the original transcripts by law cannot be provided nor distributed due to nature of the case and for protection of the minor child. Let's read that sentence again, because I would like to get a hold of the trial transcripts, and it says copies of the original transcripts by law cannot be provided nor distributed due to the nature of the case and for protection of the minor child. That's horrific. You know, if this is true, I don't know who wrote this. I don't know if this is a legal document, but they're saying that you can't distribute the original transcripts. Also, I don't know when the dates are for trial 1 and the dates are for trial 2 and the dates are for trial 3. So that's kind of missing. All right, looks like these points are numbered, so I'll just go with the numbers, I guess. Number 1, Valerie Dyer testified that Charles had no access to her computer. Trial 1.90. T1.90 is Valerie Dyer's testimony at the first trial on page 90. Okay, so Valerie Dyer testified that Charles had no access to her computer. Number 2, Amanda Monsalve testified that Charles didn't see the child after January the 3rd. PH, which is the Daubert hearing. PH.75, trial 3.5, 32-33. PH.75 is Amanda Monsalve's testimony at the preliminary hearing on page 75. The testimony is also found at T3.5, 32-33, which is Amanda's testimony at the third trial on pages 5 and 32 through 33. Okay, we got Valerie Dyer testified that Charles had no access to her computer. Amanda Monsalve testified that Charles didn't see the child after January the 3rd. Give me just a second, there's a lot of background noise. I'm going to shut some doors here. Okay, no problem. Alright, so we're going to, whoops, we can get the audio better here. Okay, number 3, search warrants were issued for Charles' home, see evidence folder. Number 4, Valerie was recorded saying she won't say anything in court that could cause her to lose custody of child. See redacted conversation Charles and Valerie, pages 2, 4, and 5. Number 5, through testimony, Valerie admits that she and Charles argued over custody. PH.110, T1 32 through 37 through 39, 72-73, 83-87, T3.54, 59, 145. Number 6, Amanda Monsalve, Charles's girlfriend, testified to custody issues between Charles and Valerie. PH.79, 84 through 85, T1.11, T3.14, 19 through 24. Number 7, Charles Dyer testified to a heated divorce and custody issues. T1.25, 30 through 31, 34-35, 40-41, 88-89, 94, T3.128-130, 134-136. Number 8, Amy Dark, Charles's sister, testified to her knowledge of custody issues. T3.7-8. Number 9. The month prior to the sexual abuse allegations, Valerie's computer was used to access www.myoutofcontrolteen.com, as computer expert Marvin Dutton testified. T1.16. This website is marked evidence item number 23-C in the post-conviction relief brief and explains how to win a custody battle. Valerie Dyer was recorded voicing her concerns that she would lose custody of child to Charles, as well as her willingness to lie if necessary to keep this from happening. Charles and Valerie conversation transcript, pages 2, 4, and 5. Number 11. Valerie acknowledges that she denied visitation to Charles and that he had called police over it. Post-conviction relief, brief evidence number 1, transcript pages 1 through 2. Charles testified that he recorded this conversation after an altercation concerning Valerie allowing child to be around a convicted child molester, and after he threatened to report it. Valerie denied visitation and lied to police, telling them there was no visitation agreement. T3, 28 through 31. Number 12. Valerie admitted that in June 2009 she threatened to say or do anything to prevent Charles from gaining custody of child. PH.110, T1.38 through 39. Charles testified that he was arrested by military authorities on false charges after this threat. T1.25 through 28. Valerie admitted that in July of 2009 she told Charles that she would do anything, including perjury, to keep Charles from getting his daughter, child. T1.72. Number 14. In a recorded conversation, Charles accuses Valerie of threatening to commit perjury, to which she does not deny. Valerie further states that she won't say anything in court that may jeopardize her retaining custody of child. Evidence item number 1, transcript pages 2, 4 through 5, post-conviction relief brief. Number 15. Valerie admitted at Daubert hearing that she told Charles that she would do or say anything to keep Charles from gaining custody before the sexual abuse allegations were made. DH.14. Number 16. At the trial that resulted in a guilty verdict, Valerie denied ever making any of these threats. T3.108 through 111, 150-154. Number 17. Charles testified that he was stationed in California while Valerie and child lived in Oklahoma. T3.18, Valerie corroborated this. T3.44. Number 18, Valerie testified that she and Charles communicated by phone and webcam. T1.27 through 28, T2.62. Number 19, Valerie admitted to threatening Charles that she would say or do anything to prevent him from going custody of child during this time. PH.110, T1.31 through 32, 38 through 39. Charles corroborates this. T3, 128 through 130. Number 20. After this argument, Valerie instructed her brother to call Charles's command and file charges against the state. File charges stating Charles threatened to kill Valerie and child over the phone. Charles testified to this. T1.24 through 28, T3.130 is corroborated in part by Amanda Monsalve, T1.19, and Amy Dark, T1, 7 through 8. Further, in a recorded conversation, Valerie admits these charges were false by stating, "I never said that you had threatened to kill me or my daughter." Evidence number 13, transcript post-conviction relief brief, pages 15 through 16. 21. Over the course of 2 years, Valerie was never able to give a precise date that child disclosed sexual abuse to Valerie. However, Valerie testified that child was in Valerie's custody before school began, after the Christmas break, January of 2010. School records show that school started January the 4th, 2010. Evidence item 14-B, post-conviction relief brief. Valerie agrees that if this is accurate, Valerie picked child up on January the 3rd, 2010. Valerie testified multiple times that she learned of the sexual abuse this night and reported the abuse the next day. January the 4th, 2010, PH.114, DH15, 20, T1, 51 through 52, 80 through 81, T3.125. The fact that the child left Charles's custody on January the 3rd, 2010, and this was the last time Charles saw child, was corroborated by Charles Dyer. T1, 49 through 51, T3, 138, Amanda Monsalve, PH.74, T1, 15 through 17, T3, 32 through 33, and Jan Dyer, T1, 15, T3, 177. 22. The previously mentioned testimony by Valerie that she learned of the sexual abuse on January the 3rd, 2010, and reported it to police on January the 4th, 2010, isn't even a possibility. Though Valerie testified to this and further that child didn't attend school this week. T1.80. It's simply untrue. School attendance records prove that child attended school from January the 4th through the 7th of 2010 and was only absent January the 8th of 2010. Evidence item number 14A, post-conviction relief brief, further testimony of Deputy Seeley, T1, 11 through 13. Deputy Seeley's affidavit, evidence item number 17, post-conviction relief brief, and Valerie's own police report, evidence item number 18, post-conviction relief brief. There was no report to police. Was made until January the 8th, 2010. Valerie has been asked to explain the discrepancy, but has never been able to. T2, 80 through 81, T3, 125 through 126. Thus raising questions that Valerie Dyer either 1. Learned of the abuse on the day the child left Dyer's home, and then sent child to school and made no report for 5 days, making Valerie's testimony of reporting the next day and the child missing school as untrue. Or 2, Valerie learned of abuse on January the 7th and her testimony of child crying, complaining that her vagina hurt, making disclosure after leaving Charles's home, was untrue. No matter the scenario, it is undisputable after leaving Charles's home was untrue. No matter the scenario, it is undisputable that Valerie lied under oath concerning the disclosure of child and reporting abuse to police. This evidence was not presented to jury other than being mentioned in part briefly. At the trial, that resulted in a guilty verdict. The state claimed that Valerie had no anger towards Charles or Amanda Monsalve during the month of December 2009. Before the allegations, and therefore had no motive to fabricate charges. Valerie testified that she had no ill feelings toward Charles and Amanda in December of 2009, T3.129. Valerie testified that she no longer wanted to be in a relationship with Charles around the time of the sexual abuse allegations, T3.139. Evidence proves these statements to be false. In a recorded conversation, Valerie states that she was devastated over learning that Charles and Amanda were in a relationship together. That Valerie still loved Charles and still wanted to be with Charles, December 2009. Evidence number 13, transcript page 14, post-conviction relief brief. Valerie's anger towards Charles can be seen by a MySpace posting from December the 14th, 2009, in which Valerie states, "Let's all pray Charles's penis falls off, shall we? And let's all hope his penis falls off." Evidence number 13, post-conviction relief brief. Further, in a recorded conversation, Valerie states that she hates Charles and makes several derogatory comments about Amanda's weight, ethnicity, and states that Amanda was lucky Valerie didn't bust her face in. Evidence item number 13, transcript pages 8, 33 through 36, post-conviction relief brief. Valerie testified that during October 2008, May of 2009 timeframe, Charles abandoned Valerie and the child in Oklahoma with only $126. T2 54 through 55, T3.47. that Valerie had to save up money to buy a car and rent a house, T2.60, and Charles never sent money to help her, T3.50. However, this is untrue, as Valerie admitted that Charles paid Valerie's rent, T3.116, and Valerie had housing before she even had a job, T3.49 through 50. Further, Valerie testified that Charles paid child's daycare, T3.61, beyond Valerie's testimony. Check stubs prove an additional $1,200, not counting rent and daycare, was paid to Valerie by Charles during this time. Evidence item number 21-B, post-conviction relief brief. Additionally, during a recorded conversation, Valerie admits to John Dyer that Charles paid for her car. Evidence item number 1, transcript page 5, post-conviction relief brief. Number 25. Valerie testified that she openly admitted that she committed adultery to Charles and never lied to him about it. T3.55-119. This is contradictory of previous testimony by Valerie that she did in fact deny committing adultery when Charles confronted Valerie about it, T1.69. Number 26. Valerie testified at trial that she only used drugs one time, T3.111. In previous testimony, Valerie testified that she used drugs multiple times and listed 4 separate places that she left child while using drugs, T1.33, T3.56 through 57, 56 through 67. Beyond this, Valerie admits she used to do drugs, evidence number 13, transcript page 18, post-conviction relief brief, and never says her drug use was a single act in a recorded conversations. 27. In the trial resulting in the conviction, Valerie testified that Charles never allowed her family to come to the hospital to see child when she was born because Charles was controlling and mean. The defense proved Valerie was lying by presenting multiple pictures of Valerie's friends and family in the delivery room holding the child. Valerie then claimed that she had meant that Charles wouldn't allow her family in the hospital during child's birth, but did the next day. T3.134 through 137. However, this is not what Valerie meant, as her previous testimony was specifically that Charles never allowed Valerie's family to visit Valerie or child while Valerie was in the hospital after birth. T2.35. And she gave this false testimony with tears in her eyes and dabbing her nose with a tissue given to her by the prosecutor. T2.33. 28. These and over 30 other acts of perjury by Valerie Dyer are explained in detail in evidence item number 25, post-conviction relief brief. None of this was brought to the jury's attention. Number 29. Charles Dyer testified to Valerie's tendency to lie. T1.26 through 29, 34, 35, 52 through 53, T3.121 through 122, as did Amanda Monsalve, T3.6 through 7. Valerie partially corroborates this, T3, 97 through 98, and doesn't deny it when Charles states, "You've done nothing since we've been together but lie," during a recorded conversation. Evidence item number 1, transcript page 6, post-conviction relief brief. Number 30. Charles testified that Valerie had problems with abusing prescription drugs and would cut herself with razors. T3, 109 through 110, Valerie confirms this. T1.92, 95 through 96, T3.100, 140. Amanda testified that Valerie offered Amanda prescription medication while they were drinking alcohol. T3, 7 through 11. Valerie also wrote to Charles in 2007 and admitted that she obtained prescription medication illegally from a family member. Evidence item number 28 through -C, post-conviction relief brief. Valerie admitted to taking Zoloft, lorazepam, and Xanax. You know what? I'm not going to read any of these numbers anymore because if you guys want the numbers, you can read the PDF file. But it's just too much numbers, and I want to read the actual meat of the document. So I'm just going to read the meat of the document. You guys can look at the PDF file for the actual numbers. Valerie admitted to taking Zoloft, lorazepam, and Xanax. Charles testified that Valerie abused Xanax and Valium, and it caused problems while he was in Iraq. Charles testified that these problems resulted in Charles not being allowed to deploy a second time to Iraq. Valerie corroborates that Charles didn't deploy because of her medical issues. Number 31. The prescription medication that Valerie was taking legally was for her depression and suicidal thoughts. Valerie wrote in a letter that her mother made fun of her for taking them and called them crazy pills. Evidence item number 28 through A, post-conviction relief brief. Amanda testified that she contacted a military support group to contact Valerie because Amanda was concerned from Valerie's depression. Number 32. This is clear evidence that Valerie has issues with being truthful, which is undeniable in combination with Valerie's acts of perjury. This evidence also suggests that Valerie had issues with depression, cutting herself, and abusing prescription medication. Number 33. Valerie admits that her uncle James Hikia is a registered sex offender. Valerie admits that James lived with Valerie's mother. Teresa Wiley, Valerie admits to leaving child at Teresa's residence while Valerie was elsewhere using drugs. The child admits that she went to Teresa's home after school every day. Evidence proves that James Hikia was charged with exposing himself to a 4-year-old WH, whatever WH stands for. James admitted to exposing himself to his cousin TB. James admitted to commit lewd acts on a 16-year-old. Teresa lied to police about James living with her during January 2010, but James did in fact live there at this time. And James was arrested for living in Teresa's home illegally. Number 35. Charles Dyer testified that the last day he saw the child was January the 3rd, 2010. This is corroborated by Amanda Monsalve. Valerie corroborates that Charles didn't have child after school started. Yeah, Valerie corroborates that Charles didn't have child after school started. School records prove that school began January the 4th, 2010. And that child attended school from January the 4th through the 7th, 2010. Evidence proves that the report of sexual abuse was January the 8th, 2010. Valerie testified time and time again that child complained of her vagina hurting and was crying from the moment she was picked up the previous day. This corroborated by Amanda, who testified that Valerie had told her child made disclosure Thursday, and by Dr. Waters, who reported that Valerie stated she had learned of the sexual abuse Thursday. Number 36. This evidence proves that child attended school Thursday, January the 7th, 2010. Child went to James's residence after school, and if child complained of her vagina hurting, it was 4 days after her seeing her father and immediately coming from a sex offender's home. Further, child claimed that Teresa showed child her vagina in her home. Let me read that again. Further, the child claimed that Teresa, I believe Teresa is the mother of Valerie, if I'm not mistaken, showed the child her vagina in her home while sitting at the computer with legs up and no underwear on. Wow. This disclosure was made to Jan Dyer, who in turn notified Charles. When Charles told Valerie, Child denied telling this to anyone. However, Child did finally admit this to Valerie. Valerie acknowledged this in a recorded conversation, evidence number 13, and all the numbers that's associated. None of this evidence was presented to the jury. The child's testimony against Charles Dyer is inconsistent with the facts, is contradictory of itself, contradicted by others, is unclear, uncertain, and improbable, according to Oklahoma state law. Child's testimony must be corroborated by evidence linking the accused to a crime, and no corroborating evidence exists. His imprisonment is a violation of Oklahoma state law and due process, guaranteed under the United States Constitution. Being such, Mr. Dyer should be released immediately. According to Oklahoma state law, a rape victim's testimony must be corroborated by evidence linking the accused to the rape in the following instances. Number 1. The victim's testimony is contradictory, unclear, or uncertain, improbable, impeached, or inconsistent. Number 2. There are indications that the prosecution maliciously conspired. Number 3. The accused denies the allegations against him and his testimony is corroborated. 37. The tape interview, evidence item number 7, the taped interview of child and her in-court testimony is clearly contradictory, unclear, and uncertain, improbable, and inconsistent. Contradictory. During the interview, evidence item number 7, that's all the numbers. During the interview, child states 6 times that she was last raped on January the 2nd, 2010, 4 times that she was not raped on January the 2nd, 2010. Let me read that sentence again. It's got a lot of numbers in here too. During the interview, child states 6 times that she was last raped on January the 2nd of 2010, 4 times that she wasn't raped on January the 2nd, 2010, and 1 time that she doesn't remember. Number 2, child states in the interview that she was last raped on Charles's bed and then later says the last time was on a couch. Number 3, child states that Charles does different sexual acts to her at different times, then later says he does the same thing every day somebody leaves. Number 4, child states that she performed oral sex on Charles January the 2nd, 2010, then later says she didn't do anything to Charles's body on January the 2nd, 2010. Number 5, during the first trial, child testified that she didn't remember anything unusual about Christmas break, December 2009 through January 2010, while at Charles's home. Inconsistent. Number 1, during the forensic interview, child states that Charles's pillows are white. Testimony by Deputy Lemons, Deputy Seeley, and the search warrants prove Charles owned only green and brown pillows. Number 2, child states Charles raped her while Valerie was at work in California. Valerie testified that she never held a job in California. Number 3, child stated in the interview that she was raped on Charles's bed and, I think it means couch, but it says cough. Though Dr. Waters testified that a child of this age would bleed from intercourse, no blood or secretions belonging to the child were found in the home and no semen, blood, or secretions were found on child's unwashed panties worn on the day of the alleged rape. Improbable. Number 1, it is improbable that no DNA evidence would be found after the intercourse described by child. Number 2, child states during the interview that she disclosed the sexual abuse to her mother on Sunday, January the 3rd, 2010, while bathing. However, this isn't likely as Amanda testified to child bathing just hours before leaving Charles's home. Number 3, Charles stated that she was, let me read that again. Number 3, child stated that she was raped multiple times at Charles and Amanda's home. However, Charles and Amanda both testified that Charles was only left alone with the child once and was never alone with child on January the 2nd, 2010. Unclear or uncertain. Number 1, during the forensic interview, child is asked about what specific sexual acts occurred on January the 2nd, 2010. At one point, child states, I don't remember the whole story. I don't remember the whole story. That sounds like she's being coached, doesn't it? Number 2, Jessica Taylor, forensic interviewer, testified that she herself was confused as to what sexual abuse had occurred. Number 3, the child testified that she was unsure if what she said in the interview was correct. Number 4, Jessica Taylor testified that child was confused during the interview. Number 5, child is unable to describe anything about Charles and Amanda's bedroom. Number 6, child is unsure how she remembers the date of January the 2nd, 2010. During the interview, child states, "I don't know, I don't remember, I have no idea," 18 times. Maliciously inspired prosecution. A custody battle and divorce at the time the allegation was made. Number 2, Valerie threatened to do anything, including lie in court, to stop Charles from gaining custody of the child. Number 3, suggests that Valerie has no problem using government agencies to wrongfully arrest Charles. Number 4, Valerie lied about the sexual abuse, disclosure, and events surrounding it. Number 5, reveals 45 acts of perjury by Valerie. Number 6, presents evidence suggesting child was coached what to say. Number 7, proves Valerie's computer was used to research web... Let me read number 6 again. Presents evidence suggesting child was coached on what to say. Number 7, proves Valerie's computer was used to research websites containing information about winning custody battles and reporting sexual abuse over a week prior to the alleged disclosure by child. Number 8, proves Valerie's computer was used to view pornographic videos for an 8-hour period the evening prior to child's forensic interview, where child is asked to describe sexual acts. Keep in mind that Valerie's computer, Charles had no access to her computer. Corroboration of the accused. Charles testified and denied the allegations of raping child, and his testimony is corroborated by the testimony of Amanda Monsalve and Jan Dyer. He is also corroborated by the DNA report and forensic computer reports. Number 38, all 3 instances in which a rape victim's testimony must be corroborated by evidence applies to this case. The only evidence presented is medical examiner Dr. Waters. He testified that although the examination is suspicious, he can't say for certain that sexual abuse even occurred. This evidence doesn't show that sexual abuse occurred at all, let alone that Mr. Dyer was the perpetrator if it had. According to Oklahoma's definition, OUJI-CR97, in order to be corroboration, the evidence must tend to connect the defendant with the commission of the crime charged. There is absolutely no other evidence against Mr. Dyer. In fact, the only evidence against him is the testimony of the child alone. Holding Charles Dyer in prison is a violation of Oklahoma state laws and the due process guaranteed of the Oklahoma Constitution and the 5th and 14th Amendments of the U.S. Constitution. His incarceration is a miscarriage of justice, and he should be released immediately. 39. The child was given forensic interview where she was asked to describe sexual acts. This interview was given January the 12th, 2010. The evening prior to this interview, Valerie Dyer viewed numerous pornographic pictures, videos, which could be suggestive that Valerie Dyer did this to instruct the child in what to say during the interview. It could also be suggested that once Valerie was satisfied that the child was sufficiently coached, she sent an online message to Charles Dyer and Amanda Monsalve, laughing at them and wishing Charles good luck because he was going to need it. Undisputable proof of this is as follows. Let me just stop right here and say this, that if you're a mother, you remember in the Bible when you got 2 moms and Solomon said, let's cut the child in half and give each half to the mom, and the mom who really loved the baby said, no, don't cut the baby in half, it's not mine. She said, and King Solomon said, give the baby to that mom because that mom cares about the baby. If you're Valerie and your precious daughter had just been raped by the father and your husband, you ain't going to be sending vindictive messages on Facebook like, good luck, you're going to need it. You know what I mean? You're not going to do that. You're going to do everything you can to disassociate with that devil from hell who just raped your daughter. You're not going to be sending him messages like, good luck, you're going to need it, and I wish his penis, you know, you're not going to be saying that. You're going to be saying, you're going to distance yourself. And so this is evidence to me that Valerie is an incredibly vindictive woman, and she's very conniving. And the point that's been driven home to me so far as I'm reading this is there is zero evidence outside the testimony of that child that Charles did this at all. Zero evidence. Number one, on December the 25th, 2009, Valerie's computer is used to access topics.law.cornell.edu and search the phrase legal rights over a child, which led to U.S. Code Title 18-3509. The title explains what questions a child will likely be asked while testifying, as well as information concerning videotape depositions of a child. Number two, Valerie testified that she knew what was expected of a child during the forensic interview and states that Valerie prepared the child for the interview. Number three, on January the 11th, 2010, the day prior to child's forensic interview, Valerie's computer was used to access redtube.com, a website to view pornographic videos multiple times over an 8-hour period. This is reflected by the OSBI report, pages 2 and 3. Report reads 1/11/2011. This is a typo that should read 1/11/2010. The state acknowledges this. Further, page 2 reflects that the last date of the computer use on January the 13th, 2010, and page 8 confirms that all pornography was viewed between December 25th, 2009 and January the 11th, 2010. Valerie is directly linked to the viewing of this pornography as follows. The OSBI report reflects a search for Amanda Monsov on page 8. The search was done on myspace.com on January the 11th, 2010 at 8:23 p.m. Amanda Monsov testified that Valerie sent a MySpace message to Amanda on January the 11th, 2010. Valerie corroborates this. The message is and shows Valerie laughing at Charles and Amanda. Pornography was viewed at 20:33, just minutes after this MySpace search, as the OSBI report proves. Number 5, 438 temporary internet images were downloaded January 11, 2010 due to accessing redtube.com. These images reflect similar content as contained in the online videos that were viewed. A sample of 51 of those images can be seen as evidence item number 16B from the OSBI computer report. Number 6, child's description of sexual acts are identical to these images. During the interview, evidence number 7 states that during the interview, child states semen is yellow. Images of semen are found on Valerie's computer. She was raped on a couch and bed. Images of sexual acts on couches and beds were found on Valerie's computer. Charles performed oral sex on her. Images of males performing oral sex on women are found on Valerie's computer. Alright, I'm at the bottom of page 14. I'm going to pause here and pick up later. I've got to take a break. It's 41 pages total, so we've got quite a bit to go before we get to the end. Alright, we're going to pick up at the top of page 15 and continue on as far as we can. We're on top of page 15, got to go to 41. Images of sexual acts on couches and beds were found on Valerie's computer. Charles performed oral sex on her. Images of males performing oral sex on women were found on Valerie's computer. D. Charles' pillows were white. Search warrants, it gives the places where she said that. Testimony of Deputy Lemons and Deputy Seeley proved Charles had only green and brown pillows. However, images of sexual acts on beds with white pillows were found on Valerie's computer. She performed She performed oral sex on Charles and described swirling her tongue around his penis. Images of females swirling their tongues around penises were found on Valerie's computer. All of these images were downloaded within 24 hours prior to the child's forensic interview, where she describes these acts. 40. In the forensic interview of child on January the 12th, 2010, Child tells interviewer that she was last sexually abused on January the 2nd specifically. The interviewer becomes suspicious and asks why the child says this date. Child replies, "I don't know." The interviewer asks, "How do you remember that day?" To which the child answers, "I told my mom I don't remember it, and now I know." 41. The forensic interviewer asks what Charles Dyer does to child's vagina, and child answers, "I don't remember the whole story." 42. During the first trial, Charles testified the child's claims of sexual abuse at Jan Dyer's home during 2009 were impossible because he lived in a tent and only slept under the same roof as the child once. This was corroborated by Jan. This was a major blow to the state's case. So a year later, upon direct question by the prosecutor, child says she was raped in a tent. However, she's unable to describe anything about the tent. On cross-examination, the defense asked child when she had first mentioned anything about the tent to anyone. Child stated that she never told anyone until the day prior while in the prosecutor's office. This was one day before the third trial, 2 years, 9 months after this alleged rape. While coincidentally being prepared for trial in the prosecutor's office, if this weren't enough to be suspicious, Valerie also mentions the tent for the first time ever on this same day. Valerie testified that in December 2009, Valerie's relationship was good with Charles and Amanda Monsov, and that Charles took child on motorcycle rides, took her hiking, and camped in the backyard. This was a clear attempt at trying to insert some type of testimony to corroborate the prosecution's newly acquired testimony of child, because no one would do any of these activities with a child when temperatures rarely rose above the 40s and were well below freezing nearly every night, as proven by a bunch of numbers. 43. Child answers January the 2nd to questions that had nothing to do with dates, as if it were a learned response. 44. Valerie testified that child was grabbing her vagina and crying when Valerie asked what was wrong. Child stated that Charles touched her. Child, however, testified that Valerie never once asked if something was wrong. Child states that she did nothing to provoke questions from Valerie, and that Valerie was the one that first suggested that Charles had touched child. 45. Valerie testified that she never brings up the subject of sexual abuse with child. However, Valerie is recorded saying that she asked child about the abuse and interviewed child numerous times, as well as the fact that child goes into explicit detail with Valerie concerning sex acts. Valerie likely testified multiple times that she never spoke with child concerning the abuse because, as she stated, state prosecutor had advised Valerie not to. None of this evidence was presented to the jury. 46. Computer expert Marvin Dutton testified that from December the 25th, 2009 to January 1st, 2010, Valerie's computer was used to do approximately 20 internet searches, accessing websites containing information regarding what is required to convict someone of crimes against children, sexual abuse, and misconduct toward a child, child abuse, adoption, and custody. Websites searched included cornelllaw.com, childwelfare.gov, lawinfo.com, and myoutofcontrolteen.com. Examples of information on these websites are as follows: childwelfare.gov, penalties for false reporting of child abuse, grounds for involuntary termination of parental rights, myoutofcontrolteen.com, how to win a custody battle. 47. After the first trial in which the evidence was presented to by the defense, the state used OSBI to do an independent examination of Valerie's computer to refute Mr. Dutton's findings. The OSBI confirmed Mr. Dutton's findings and further found that their websites and pornographic websites were viewed during the same time frame of December the 25th, 2009 through January the 12th, 2010, beginning 8 days before Valerie's claims the child made disclosure, January the 3rd, 2010. Evidence number 48. Valerie testified that Charles had no access to her computer for over a year prior to this time. None of this evidence was presented to the jury. 49. Jessica Taylor, forensic interviewer, testified that child forensic interview was conducted January the 12th, 2010. 50. The OSBI forensic report shows 9 instances of access to RedTube.com, which is a pornographic website in which videos depicting adults in sexual acts can be viewed. The only day that this website is accessed more than once is January the 11th, 2010, and has done so repeatedly over an 8-hour span of time from 12:25 p.m. to 8:36 p.m. The report reflects the year as 2011. This is a typo that should read 01/11/10. The OSBI in the state of Oklahoma recognized this error. This is further corroborated by page 2 of the report, which states the computer was last used January 13th, 2010. 51 photographs similar to what can be viewed on this website can be seen in evidence item number 16B, post-conviction relief. 51. The OSBI report also reflects an internet search for Amanda Monsov on this same evening. Note, the year should read 2010 as mentioned above. Coincidentally, this search on myspace.com for Amanda Monsov was done within minutes of pornography being viewed. Also, Valerie sent Amanda a message on MySpace this very evening, laughing at Amanda and wishing Charles good luck because he will need it. The subject line was "ha ha ha ha," and it is marked. Valerie admitted sending this message. This places Valerie at the computer within minutes of pornography being viewed. 52. All of this evidence is consistent with Valerie potentially coaching the child on January the 11th for the interview the next day with the aid of pornographic material. Valerie admits that she knew what was expected of child at the interview, and Valerie prepared child for it. Once Valerie was confident that the child could remember dates and describe sex acts, Valerie sent the MySpace message to Amanda, laughing at she and Charles. This act alone suggests that Valerie wasn't angry that her daughter had just been raped, but rather spiteful for Amanda taking Charles, and maliciously laughing that Valerie had won the very custody battle she had begun researching how to win just 2 weeks prior. None of this was presented to the jury except that Valerie had sent a MySpace message to Amanda. 53. Valerie claims that she learned of child sexual abuse on January the 3rd, 2010. This date is confirmed by Charles Dyer, Amanda Monsov, and Jan Dyer, and that this was the last day Charles saw the child. 54. The sexual abuse allegedly occurred just 24 hours prior on January the 2nd, 2010. 55. Valerie testified that she reported the incident the next day. Yet no police report was made until 5 days later on January the 8th, according to Deputy Seeley, his affidavit, and Valerie's police report. 56. Dr. Waters testified that DNA could be gathered from a rape victim up to 3 days after the rape, and damage to the vagina could be seen up to 7 days after the rape. This gave Valerie 48 hours to seek medical attention for child to gather DNA evidence, and 6 days to gather evidence a rape had even occurred. However, Valerie sought no medical treatment for child, even though Valerie claims child's vagina was red, swollen, and open. By the time police were contacted, January the 8th, 2010, there was still 24 hours to obtain evidence of recent sexual abuse, according to Dr. Waters, yet no medical exam was done until January 13th, 2010, which was 10 days after alleged disclosure. 57. Child claimed that Charles Dyer's pillows were white. The search warrant executed on Charles's home specifically mentions that police sought to collect photographs of the interior area of the residence to be used to verify the disclosure of the victim child. Yet the state claims that no photographs were taken of the Charles's bedroom. Any taken would corroborate testimony of Deputy Seeley, Lemons, and the search warrant that Charles had no white pillows. 58. Amanda Monsov was present with Charles all day on the date child claims she was raped, January 2nd, 2010. However, law enforcement never attempted to question Amanda, though she sat in the sheriff's office for 8 hours after Charles's arrest. 59. Jan and John Dyer were in their home during the times child was allegedly raped. There during July 2009, yet law enforcement never once attempted to question either of them. 60. Valerie claims that child was absent from school the week of child's disclosure. School records prove child was only absent January the 8th. 61. Valerie admits she could have taken pictures of the damage to the child's vagina but didn't. Also, Valerie didn't want to record child's disclosure. 62. All of this evidence is unusual, unreasonable, or neglectful, and indicative of foul play by Valerie and or the state of Oklahoma. 63. The OSBI forensic examination evidence proves the following. Number 1. 2DE shows that all residents of the home had left skin cells, epithelial DNA on Charles and Amanda's bed. Child skin cells were not present, though this is where the rape allegedly occurred. Deputy Lemons testified that the bed linens had not been recently washed. Number 2, or it says 1, but I think it means 2. 2DS, 2GE, 2GS, and 3BS are all sperm or bodily secretions from Charles Dyer or Amanda Monsov. 3. Dr. Waters testified that there would be bleeding after intercourse with a child of child's age. However, no blood or secretions belonging to child were found anywhere in the home. 4. No blood or secretions were found on the panties child had wore before. During and after alleged rape, Amanda testified that these panties were unwashed since alleged rape. Deputy Lemons confirmed that child's panties and pajamas were taken from the dirty clothes hamper, and Valerie Dyer corroborates that child left clothes at Charles's home. Number 64. Valerie Dyer was allowed to testify that Charles Dyer was angry about Valerie bringing a child into the world, called child cancer in Valerie's stomach, and punched her during pregnancy while being disgusted at Valerie's pregnancy. Valerie testified that Charles faked being happy about the pregnancy while around others, only rubbed Valerie's belly once during pregnancy, and refused to allow her family to come to the hospital after child's birth. Valerie testified that Charles forced her to move to Tennessee because he was a controlling mean and didn't want Valerie's family around child. Valerie testified that Charles refused to help raise child, cussed at Valerie over child, and wouldn't hug or hold her. Valerie testified that Charles was angry at Valerie for giving child attention and he neglected child. She testified Charles told Valerie that child was in his way and had no interest in child, controlled Valerie and didn't want Valerie around her family, and even grounded Valerie from the phone from calling her family. Valerie testified that Charles abandoned she and the child in Oklahoma with $126, never called to speak to child unless Valerie pushed the issue, was angry that Valerie moved out of his parents' home, and he never sent money to help Valerie or child. 65. No evidence was offered to support even one single claim Valerie made. On the contrary, proves that 7 of these 21... Okay, I'm going to stop at the top of page 23. Alright, picking up at the bottom of page 22. No evidence was offered to support even one single claim Valerie made. On the contrary, proves that 7 of these 21 statements were completely false. Not even one of these statements had any bearing on the facts surrounding the case, but they were allowed by the trial judge. 66. The only evidence against Mr. Dyer is the testimony of the child, which, as shown in proof number 8 and 9, is unworthy of belief. The only other evidence even presented in the medical exam, in which the doctor admits does not prove sexual abuse even occurred. The court and the prosecutor allowed this prejudicial testimony because the evidence wasn't enough to prosecute Mr. Dyer at the first trial. This is a serious miscarriage of justice. 67. The following is an appellate proposition proving prosecutorial misconduct. 4. Prosecutorial misconduct. Improper attempts to impeach defendant. Number 1. The state attempted to improperly impeach petitioner by making it appear petitioner was giving conflicting statements about Valerie going to her boyfriend's house the weekend after petitioner's arrest, and whether or not an argument on December the 20th, 2009 had caused Valerie's boyfriend to end their relationship. Petitioner had no knowledge of whether or not Valerie was lying about going to Oklahoma City, or if she was still in a relationship with her boyfriend even. Petitioner testified previously that Valerie had used this is a reason he couldn't see his daughter. The prosecutor was very argumentative and insinuated that petitioner was lying about Valerie's relationship ending because of the December the 20th argument, even though Valerie had, just days prior, testified that her relationship did in fact end shortly after this argument. There was no reason in these insinuations, and the state knew petitioner's testimony was corroborated by their own witness. Number 2. Okay, I've got to pause it, sorry. Alright, we're picking back up at the top of page 24. The prosecutor became extremely argumentative and insinuated that petitioner was lying about Valerie asking for child support after the disclosure was made. The prosecutor even starts to hand the transcripts to the petitioner, but the court stops her. The state then insinuates during closing arguments that petitioner is lying about this and only now bringing it up. However, 1 year earlier, petitioner does in fact mention that he spoke to Valerie on January the 6th, 8th, and 11th, 2010, and that Valerie asked for child support on January the 9th, 2010. Petitioner was asked nothing about Valerie asking for money on January the 6th. The state insinuating that petitioner was lying about speaking to Valerie about daily activities after the allegations in light of Valerie's own testimony corroborating this, and trying to impeach over testimony that the prosecutor knew or should have known was actually accurate, were acts for impeachment in bad faith. Number 3, the state attempted to insinuate that petitioner was lying about Valerie wanting a divorce while they lived in Tennessee in 2003-2004 because he had never mentioned it before. Actually, petitioner did testify previously that his marriage was great until mid-2003, but no further inquiry was made by either the defense or the state into this arena to afford petitioner the opportunity to elaborate. Number 4, the prosecution is absolutely incapable of impeaching petitioner for a single statement concerning the facts surrounding this case. With the inability to do so, the state has attempted to insinuate that petitioner has lied about that which there was no opportunity to testify about previously, or testimony that well knew was true but thought could be used to create an appearance of untruthfulness. The jury saw these exchanges and no doubt gave the state's argument great weight and predisposed to believe that the prosecutors are telling the truth, that petitioner is being untruthful about Valerie's relationship ending because of petitioner, Valerie not wanting to be married to petitioner in 2003, and about Valerie asking for child support after reporting the sexual abuse. These insinuations, when added to the jury instruction number 13, which states evidence has been presented that on same prior occasion the defendant and or other witness made a statement inconsistent with their testimony in this case, no doubt called petitioner's credibility into question. These arguments by the prosecutor were aimed to do exactly that, and were not done to bring truth to the trial, but muddy the truth in bad faith. Number 5, this conduct is a violation of ABA standard, which states a prosecutor should not use the power of cross-examination to discredit or undermine a witness if the prosecutor knows the witness is testifying truthfully, as well as ABA standard 3.57, which states a prosecutor should not ask a question which implies the existence of a factual predicate for which good faith belief is lacking. Impeaching questions should not be propounded to a witness unless they are based upon facts that the prosecutor intends to present in refutation of an adverse answer. Such questioning should be done in good faith and not for the purpose of prejudicing and arousing suspicions of the jury against the defendant. The prosecutors acted in bad faith and aroused suspicion against the defendant over facts they knew to be contrary to their statements, which deprives petitioner of a fair trial to be tried on facts and truth. In a case such as this, in which the state's proof is conflicting and proof of guilt is not overwhelming, every small action can tip the scales from not guilty to guilty. 2. Prosecutor made comments in violation of ABA Standard 358. In closing argument to the jury, the prosecutor may argue all reasonable inferences from evidence in the record. The prosecutor should not intentionally misstate the evidence or mislead the jury as to inference it may draw. 1. To discredit the defense theory, the state did its best to convince the jury that there were no issues with custody or the divorce. During closing arguments, the prosecutor states, in July of 2009, defendant shows up with paperwork, divorce, visitation, custody, child support. It's worked out. There were no issues. Valerie signed it. And then further states, there's no evidence of any issue with visitation. No issues with custody. No issues really going on at that point in time. July to sometime in August. This, however, is not what the testimony showed. Valerie Dyer, during the direct examination, testified that she wasn't okay with the divorce and custody agreement. She didn't agree with it, and they only signed it because petition threatened to take child from me if I didn't, and so I signed it so child could live with me. Also saying petitioner would bring up the adultery and drug use, and I didn't want to lose my baby, so I just signed the paper. The prosecutors also had the knowledge that Valerie had previously testified to arguments at this time, stating that she told petitioner that she would do anything, including perjury, to keep petitioner from gaining custody of the child, as well as Valerie withholding visitation from petitioner over the trivial matters. This is compounded by petitioner's testimony that his fear that Valerie would follow through on this threat, as she had in the past, was so strong that petitioner even recorded Valerie at this time to catch her lying in case she made false allegations again. In this recorded conversation, which the prosecutor has heard, Valerie expresses her fear of losing custody and her willingness to lie in court to retain the custody. By Valerie's own admission, she gave petitioner problems overseeing the child. These statements of the prosecutor are willful misstatements of the facts in an attempt to mislead the jury and to believe Valerie had no motive to fabricate the allegations. The prosecutor even makes inferences that petitioner is lying about his testimony and reiterates any evidence whatsoever from Valerie or any other witness that took the stand, including the defendant, that there's real issues going on with the divorce or custody at that point in time. No. The jury cannot simply rewind their memories, and when a prosecutor uses corrupt tactics such as this, there is a real likelihood that a seed is planted that is based on the jury's expectation of the state's truthfulness. That can tip the scales from not guilty to guilty. There's a reason this conduct is not allowed, and it's the same reason the prosecutor said it, because it clouds the truth of the facts. The prosecutor argues that Valerie is neither an adulterer nor a liar. During closing arguments, he contends, woman scorned, where's the evidence? Drunken, drug abusing, affair having liar, where's the evidence? The only evidence that you have of really any of that is the defendant telling you that. Stating later, affair having liar, no evidence. As previously argued in Proposition 2C, Valerie gave several contradictory statements and statements inconsistent with the facts of this case. Valerie also committed outright blatant perjury over 40 times, as shown in evidence number 25, post-conviction relief brief. Valerie even lied about her statements that she would lie. Concerning adultery, Valerie admitted she committed adultery. In a recorded conversation, Valerie not only admits to having an affair, but doesn't deny that she lies all the time. Post-conviction relief brief. The evidence and the prosecutor's knowledge of it is that Valerie is beyond any doubt whatsoever an affair-having liar. The defense's theory is that Valerie is extremely untruthful, and the evidence completely supports this. Once again, the state corrupted its truth, and fact-finding purpose muddied the truth with willful and blatant lies in an attempt to bolster the credibility of a key witness where the truth would leave the credibility seriously lacking. The truthfulness of Valerie Dyer is the hinge on which the jury decides whether she would coach the child up and lie about it in court. By the prosecution making these statements once again, the jury is swayed to give great consideration to the state's contentions and leans this hinge ever closer to the state's side. Number 3. The state argued that child never made accusations of anyone else abusing her, despite the fact that she was given an opportunity to do so. At closing arguments, the state contended, you heard Jessica say, has anyone else ever touched you like this? Anyone ever touched you in a way that's not okay? She did. She asked that. This statement, though accurate on its face, is reliant on perjured testimony. Jessica Taylor testified to this as claimed. However, child was never asked this in the video. The only question remotely similar was when Taylor asked, has your dad done this to anyone else? The first time child is ever asked, has anyone ever touched your body in a way that is not okay is during her testimony 2 years and 4 months after the interview. During the third trial, which is more than enough time to solidly instill false ideas in a child, the misstatement of the evidence led the jury to believe that the child excluded anyone else as a possible perpetrator years prior, when the truth is that it was only days prior. 4. The prosecutor argued that petitioner felt no responsibility for his wife and child. Tell me one time he said, "I felt responsibility to my family. I felt responsibility to my daughter." When did he tell you that? He didn't, not once. There's no way to describe this except as a blatant lie to mislead the jury from the facts of the case and gain a little more prejudice against the petitioner. Petitioner clearly stated that he had a responsibility not only to his Marines but to his family as well, further testifying that these two responsibilities conflicted. 5. The prosecutor's argument is likely to have significant persuasive force with the jury. The possibility that the jury will give special weight to the prosecutor's arguments are very likely. Though the state should have the freedom to present arguments logically and with vigor, they should not feel at liberty to lie or misstate the evidence, as the prosecutors in this case have. The Supreme Court in Berger v. U.S. said that while he may strike hard blows, he is not at liberty to strike foul ones. It was also stated that intentional misstatements of evidence is particularly reprehensible. It has been long established that a lawyer may not knowingly assert a fact which has not been proved. Either the state's case is grounded in facts or it is not. In this case, it's not. Prompting the state to lie about visitation, custody, divorce issues, Valerie Dyer's credibility, opportunity of child to name other perpetrators, and the petitioner dedication to his family. These are very important facts on which the case is decided. Specifically regarding the misstatement of Valerie's credibility and issues surrounding the divorce, the jury's estimate of the truthfulness and reliability of given witnesses may well be determinative of guilt or innocence, and it's upon such subtle factors as the possible interest of a witness in testifying falsely that a defendant's life or liberty may depend. B. The prosecutor should not express his or her personal belief or opinion as to the truth or falsity of any testimony or evidence or the guilt of the defendant. 1. During closing arguments, the state implied that petitioner and Amanda Monsov were lying about when they started dating. Petitioner returns to California very interestingly, just starts dating Amanda at that point in time. Really? Does it matter? Only if you're trying to evaluate who's being truthful. Is that reasonable to believe there wasn't something going on before then? The state never introduced one iota of evidence to contradict petitioner or Amanda, but makes this comment to lower the credibility of defense witnesses' truthfulness to the jury by baseless insinuation. Number 2, prosecutor states that the petitioner is untruthful in testifying that Valerie is a drunken, pill-popping liar. By saying this testimony wasn't true, it didn't happen, it wasn't an issue. Number 3, prosecutor said that in order to believe Child and Valerie are liars, you must believe Child wasn't abused, further stating Child's not lying. This is clear violation of conduct and bolsters Child's credibility with the jurors. 4, the prosecutor argued that there was no question Child was sexually abused. This is an improper personal belief of the evidence. Dr. Waters clearly stated that sexual abuse was not definitive. The matter is for the jury to determine, and the jury from the first trial obviously had doubt. Number 5, prosecutor stated that the evidence that Child was sexually abused is uncontroverted. Same as paragraph 4. This is for the jury to determine. Number 6, the prosecutor stated Child was sexually abused. She didn't fall down. This is not what Dr. Waters testified to. No one asked Child or either parent if Child ever suffered an injury. And this matter is for the jury. Number 7, prosecutor stated it doesn't change the fact that the petitioner had sexually abused his daughter. This is another clear violation as a personal belief of guilt and states to the jury that it is fact, which the jury is relieved from determining for themselves. Number 8, prosecutor stated petitioner is guilty of this and I ask that you find him so. This is yet another complete disregard for well-established rules of conduct in favor of conviction at all cost. Number 9. These comments made by the prosecutors are a form of unsworn, unchecked testimony that exploits the influence of the district attorney's office and removes the prosecutor from his role as an impartial truth seeker, replacing himself as a one-sided advocate. The U.S. Supreme Court has long held that this very conduct is not allowed. The ABA recognizes the importance of the prosecutor being a minister of justice and not simply that of an advocate. The prosecutors in this case have clearly gone outside of this acceptable realm and have wholly presented themselves as one-sided advocates. Valerie made this clear by letting slip that the prosecutors presented themselves to her, in her words, my attorney, and said they were working for her. Beyond the subject of one-sidedness, deciding whether or not the elements of the crime are met is wholly up to the jury and shouldn't be tainted by such comments. Improper suggestions, insinuations, and especially assertions of personal knowledge are apt to carry much weight against the accused when they should properly carry none. Berger versus U.S. Prosecutors should refrain from expressing personal opinions. The state has no right in the area of argument to supply the lack of evidence or make greater the weight of evidence. These comments are also a violation of the state statutes, volunteering opinions to the veracity of a witness. Testimony, as shown in paragraphs 1, 2, 3, is improper and unprofessional. The prosecutor should not make arguments calculated to appeal to the prejudices of the jury. 1. During closing arguments, the state made comments aimed not at the facts of the case, but rather to appeal to the jury's sympathy and nurture the already well-inflamed passions against the petitioner by stating how tragically heartbroken Child is and how she'll have to live with what the petitioner did to her the rest of her life, and asked the jury to serve punishment with the consideration of how emotional Child was during the guilt-innocence phase. 2. The prosecutor argued that the petitioner loved his Marine family, but didn't love his wife and daughter. Tell me one time he said, I love my family. Tell me one time he said, I love my daughter. He didn't do it. This was quite simply another attempt to compile prejudice and had no purpose toward providing the facts of the case. Remarks calculated to evoke bias or prejudice should never be made in a court by anyone, especially the prosecutor. These comments bias the jury against the petitioner in an environment that naturally biases a jury against a defendant because it concerns the horrendous crime of child rape. These comments, while petitioner will concede may be proper in sentencing phase, have no place in the guilt-innocence phase. In a case of this nature, with such little evidence, every improper statement builds up to a tipping point toward a guilty verdict. These very comments could very well have caused the added emotional charge to a jury's sympathy for Child and anger toward the despicable character the petitioner was wrongfully painted as. A prosecutor should not encourage jurors to let improper sympathy or sentiment influence their decision. Arguments for sympathy have been consistently condemned by the Oklahoma Appellate Court. Number 3. The prosecutor allowed witnesses to lie and let perjured testimony to go uncorrected on 15 separate accounts, even regurgitating some of it in closing arguments. Valerie Dyer testified that she picked up Child from petitioner's home the night disclosure was made. She further testified that she went to the police to report the abuse the next day. Police reports, police affidavits, and prior law enforcement testimony of Deputy Seeley, of which the state is quite aware, prove that no police report was made until January the 8th, 2010, 5 days after the child left petitioner's home in alleged disclosure. This is a critical fact of the case as explained in post-conviction release brief. That prove Valerie is lying under oath about the facts of the disclosure, yet the state has not once attempts to correct this testimony. The failure to correct this testimony is a knowing and willful act on the part of the prosecution because it uncovers a situation in which every scenario leads to the same conclusion that Valerie is lying about the alleged disclosure. Number 2, Valerie testified that she hasn't discussed the sexual abuse with Child since disclosure. However, the state had knowledge that Valerie was recorded previously stating that child gave explicit detail about the abuse. Valerie questioned child and even interviewed child numerous times. As the state was responsible for recording it, cannot claim to have had no knowledge of this recording. This testimony was uncorrected by the state because it would raise suspicions that Valerie gave child mock interviews and coached child. The state, in fact, directed Valerie to not question the child, as Valerie admitted. One of the issues of argument between Valerie and the petitioner was that Valerie wanted to be in a relationship with petitioner, but he refused to abandon Amanda. Valerie was irate over this. When defense counsel questioned Valerie about her desire to be with petitioner after he came back with Amanda, Valerie stated, "I didn't want to be with him, but I was still in love with him." However, in the recorded conversation referenced in paragraph 2, Valerie clearly states that she was devastated at learning about Amanda and says, "I still wanted to be with you." This testimony went uncorrected by the state because it would show Valerie as lying and would uncover another motive for Valerie to make malicious allegations. 4. On direct, Valerie stated that she volunteered to tell petitioner that she had committed adultery. Do you recall, question, do you recall how it was that petitioner brought up the issue of adultery as you described it? Answer, well, he never knew that. I mean, that I told him that I was with someone, and then he said, well, that's adultery. Question, so you volunteered that information to him? Answer, yeah. During cross, Valerie is asked, at first, did you deny the relationship period? To which she answered, no. This is contrary to the truth, though. Valerie had previously testified that she did in fact lie to the petitioner about it, and even states that she denied it maybe an hour. The testimony affects the jury's perception of credibility and the character of Valerie, and puts in question her claim that petitioner abandoned her, she, and the child. This is why the state allowed this perjury to go uncorrected. 5. Valerie tested that I only did drugs at one time and I told petitioner. However, Valerie admitted to leaving child at multiple residences while doing drugs when asked by the state. The state allowed this testimony to go uncorrected as it would have lowered Valerie's credibility and character to the jury. The defense, number 6, the defense attempts to question Valerie about disclosure, asking, you told her you were going to get something to make it quit burning, correct? Valerie replied, I never said that. Question, when you were talking to the state just a bit ago? Answer, no. I said sit down in the bathtub and maybe it will stop hurting. The fact, however, is that Valerie said, I'll get you something for it not burning. This contradiction would bring to the jury's attention that Valerie is not recalling actual events that occurred, but rather making the story up as she goes. To show the truth of this, petitioner offers that over 2 years, 6 months, 4 separate times to testify in written police reports, this is the first time anything is mentioned of getting something to stop it from burning. The state knew this would create doubt in the jury's mind concerning the disclosure and chose not to correct it. 7. The defense attempted to question Valerie concerning her uncle molesting her in her teens, causing her to move in with petitioner's parents while petitioner was in the Marine Corps. Valerie testified that she didn't move into the Dyer home and had no problem with her relatives. However, previously, Valerie stated that she left her family to move into the Dyer home. Further, she even admits that it was because of problems she had at home. Though petitioner will concede that Valerie didn't specify the specific problems at home, the fact Valerie lied about this subject is, in whole, would go directly to Valerie's credibility to the jury. Once again, the state failed to correct this because of its accumulative harm to the state's case. 8. Valerie testified upon moving back to the Oklahoma in September 2008. Petitioner wouldn't call very much and never got on the phone to speak to child, but spoke to child only at Valerie's suggestion. At previous trial, however, when asked this exact line of questioning, the same prosecutor, Valerie testified that during this time, petitioner called all the time and said nothing of his reluctance to speak to child. When asked, did he talk and communicate with child at this time, she answered, yes. Both of these statements cannot be true. The testimony had one purpose only, and that was to bias the jury against an uncaring father for mistreating a poor, pitiful wife and mother and not wanting contact with his child. The prosecutor knew, or should have known, This testimony was false and corrected. However, he allowed this. Number 9. As explained in detail in evidence item number 25, post-conviction relief, Valerie gave conflicting testimony concerning child's demeanor, statements, and actions on the alleged disclosure statement. In the trial resulting in conviction, it is clear that Valerie's perjured testimony was calculated to prejudice petitioner, gain sympathy for a crying mother, and patch the previous hole in the state's case created by Valerie's previous testimony. That nothing was wrong with the child upon leaving the petitioner's home. There is no way the state can argue that it was unaware of this perjury, as the state possessed all evidence mentioned in Section A3. The prosecution was undoubtedly concerned that bringing these contradictory statements to the jury's attention would horribly weaken the state's case by causing concern that the disclosure was contrived. Show Valerie's willingness to lie to convict petitioner, and show Valerie can cry while giving false testimony. Number 10. Valerie testified that in 2003, while living in Tennessee, her marriage and petitioner's treatment of her was bad because child was in the way. He said to do what he wanted to do. However, Valerie previously testified that the first time she had ever heard petitioners say comments like this was in early 2009. This went uncorrected and would have placed doubt in the jury's mind, and this comment was ever made and undermined Valerie's credibility had it been corrected. Number 11. Valerie testified that she never attempted to have petitioner arrested after the sexual abuse allegations. This is untrue. Valerie reported to the police that petitioner was stalking her, and even that he had vandalized her car twice, while petitioner was on bail after the allegation. During a recorded conversation, June the 30th, 2011, Valerie admitted to telling police that petitioner slashed her tires, and further stated that she had run over something but failed to tell police petitioner was not the cause. Valerie also acknowledged that she filed a stalking complaint even though she never saw petitioner and didn't believe he was stalking her. As the state recorded this call, it was aware of this conversation. The truth of this matter would prove Valerie had no problem with using legal system to attack petitioner, and the state allowed this testimony to go uncorrected. 12. Valerie testified that petitioner did not want to go to Iraq a second time in 2008 and made Valerie tell his command that she was having problems with seizures. When asked if the reason was actually because of problems Valerie was having, she replied, "No, sir." However, Valerie previously stated to the prosecutor that petitioner was unable to deploy a second time to Iraq because Valerie was sick, having seizures, and was afraid to be alone with child, and asked petitioner to try to stay home and help take care of she and the child. As this testimony was given to the same prosecutor that was at the third trial, the state knew this testimony was false. It was calculated to paint petitioner's character as a coward, and that would use his wife to lie into the military for his selfish desires. The state had nothing to gain by eliciting the truth and knowingly allowed this testimony to go uncorrected. 13. The prosecution asked Jessica Taylor if child was able to describe petitioner's wiener, to which Taylor replied, "Yes, she was." This is a lie, as child never gave details concerning descriptors of petitioner's penis. The jury was led to believe that child gave specifics regarding traits of petitioner's penis, which no doubt would be strong and persuasive evidence of guilt. Not only was this uncorrected, it was solicited by the state. Number 14. Taylor stated child talked about her dad would take spit from his mouth and he would rub it onto his wiener before putting it inside of her bobo, and then reiterated that child said her father did this to her. The dialogue was never once stated in interview or in court testimony, but this testimony helped the prosecutor and gave the jury another statement to ponder concerning the child's ability to describe accurate sexual acts. So the state solicited it and let it go uncorrected. Number 15. Taylor states that she asked child if someone else had abused her, and child answered no. She states that this part of the alternative hypothesis procedure and the child was given the opportunity to answer this question. This is completely false. Child was asked only, do you know if your dad has ever done this to anyone else? Never is child asked if someone else abused her until 2 years, 3 months later. Not only is this an absence of part of the interviewing procedure, the testimony goes uncorrected, and the prosecutor argues this false testimony in closing arguments. 16. This isn't just one or two simple instances of overlooking a minor detail. The perjured testimony involved in paragraph 1, the inconsistencies surrounding Valerie's perjury concerning disclosure date and reporting of abuse to police. Paragraph 2, Valerie's untruthfulness about giving child mock interviews and discussing abuse details. Paragraph 3, Valerie's motives to fabricate charges. Paragraphs 4, 5, and 7. Valerie's credibility and character. Paragraphs 6 and 9. Valerie's perjury concerning child's demeanor and mood, leaving petitioner's house, and events transpiring at this time and upon returning home. Paragraphs 8, 10, and 12. Valerie's lies to gain sympathy for the state and prejudice against petitioner. Paragraph 11. Valerie's use of law enforcement to wrongfully harass petitioner. Paragraphs 13, 14, and 15. Perjury by the forensic interviewer to sway the jury into believing statements that were never made. 17. A state may not knowingly use false evidence, include false testimony, to obtain a tainted conviction. This is implicit in any concept of ordered liberty. The prosecutor has a duty to correct false evidence when it is offered. As mentioned in A5, the jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence, and it is upon such subtle factors as the possible interest of the witness in testifying falsely that a defendant's life or liberty may depend. It's the prosecutor's duty to place foremost in his hierarchy of interest the determination of truth, which petitioner contends that the prosecutor in this case failed to do. In Mooney v. Holohan, the court said that when a conviction is obtained by the presentation of testimony known to prosecuting authorities to have been perjured, due process is violated. The clause cannot be deemed to be satisfied by mere notice of hearing if a state has contrived a conviction through the pretense of a trial, which is in truth but used as a means of depriving a defendant of liberty. Though a deliberate deception of court and jury by the presentation of testimony known to be perjured, such a contrivance is inconsistent with the rudimentary demands of justice, as is the obtaining of a like result by intimidation. In U.S. v. Aggers, the court stated, if the prosecutor knew or should have known that the testimony given to the trial was perjured, the conviction must be set aside if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury. Petitioner asserts his right to due process under the 14th Amendment and the U.S. Constitution and contends that the prosecutor's conduct is a perversion of the adversarial system and destroys the trial's ability to produce just results. Petitioner asked the court to overturn his conviction on the aforementioned authorities unless the state can provide the misconduct to be harmless beyond a reasonable doubt. Despite 45 acts of perjury, District Attorney Jason Hicks refuses to prosecute Valerie Dyer as the law demands, proving corruption in the Oklahoma judicial system. Oklahoma State Statute Title 21, Chapter 17, Section 49 defines perjury as whoever in a trial makes a statement under oath that a statement is true, when in fact the witness does not believe that the statement is true or knows that it is not true, or intends thereby to avoid or obstruct the ascertainment of the truth, is guilty of perjury. Section 496 states, whoever in one or more trials makes or subscribes two or more statements under oath, when in fact two or more of the statements contradict each other, is guilty of perjury. Section 498 states, a prosecution for perjury by contradictory statements as defined in 496 of Title 21, it is necessary to prove if any of the statements is not true. Section 500 states, when committed on the trial of an indictment for felony, perjury is a felony subject to imprisonment not less than 2 years, not more than 20 years. Evidence number 25. Post-conviction relief brief proves that Valerie Dyer committed 45 acts of perjury throughout her testimony. Jason Hicks, however, has refused to charge Valerie because her lies helped convict Charles Dyer. This is proof of the corruption within the Oklahoma justice system and compromises the confidence of the people in the courts. Jason Hicks himself should be punished by imprisonment or at minimum removed from office for this reprehensible behavior. Okay, that's the end of me reading the 41 pages of Charles Dyer, Operation Floodlight. I'm going to put a link in the description bar where you can download this PDF document, and if you do not want to, if you want to send it to somebody in an email, you'll have the PDF document yourself. So thank you for listening, and let's get this out to as many people as we can. Thank you for your time. In closing, the last line of peaceful defense between a tyrannical government and the defendant is jury nullification. Educate yourself about jury nullification at fija.org. Thank you.